Welcome to the HB Media Minute, a podcast from Haynes & Boone that focuses on legal trends impacting the media and entertainment industry, intellectual property, and First Amendment law. I'm Jacob Bourne, Director of Media Relations for Haynes & Boone. Today, we're discussing an interesting and significant development in anti-SLAPP protections in the United Kingdom. Up until now, the UK has not had express protections from SLAPP suits, strategic lawsuits against public participation, but that's about to end. After some significant wake-up calls in the UK to the prevalence of this form of judicial harassment, Parliament has proposed anti-SLAPP protections be amended to the Economic Crime and Corporate Transparency Bill currently progressing through Parliament. Today, the head of our Haynes Boone Media and Entertainment Practice Group, Laura Prather, will interview Susan Cawtrey, co-founder of the UK Anti-SLAPP Coalition, about the developments in implementing protections against SLAPP suits in the UK and how we got here. Laura is an experienced trial and appellate attorney who has litigated against SLAPPs in court across the country and has advocated for and been instrumental in the passage of anti-SLAPP law throughout the U.S., recently returning from a stint as a Fulbright scholar studying global freedom of expression issues. Susan serves as director of the Foreign Policy Center, an international affairs think tank, having previously worked for many years in human rights advocacy. She's the lead author for the reports Unsafe for Scrutiny, examining the pressures faced by journalists uncovering financial crime and corruption around the world, and London Calling, the issue of legal intimidation and SLAPPs against media emanating from the United Kingdom. Both these reports have been cited by the UK government, parliamentarians, and media, highlighting how reporters face risks to their freedom and security from vexatious lawsuits, SLAPPs, to violence for exposing wrongdoing. Susan was instrumental in establishing the UK Anti-SLAPP Coalition and has helped expose the devastating impact SLAPP suits can have on journalists and others who speak truth to power. Aside from legislative initiatives, Susan has also worked on efforts to improve regulation with the Solicitors Regulation Authority, which regulates solicitors in England and Wales, taking forward a key recommendation and publishing a warning notice on SLAPPs last November. Before we get started, our disclaimer. This podcast is for informational purposes only, is not intended to be legal advice, and does not establish an attorney-client relationship. The topics we discuss are subject to change. Legal advice of any nature should be sought from your legal counsel.
Thanks, Jacob. Susan, welcome to the HB Media Minute podcast. We're so happy to have you here today. Let's start our discussion by talking about the great work that the Foreign Policy Center does and the Unsafe for Scrutiny report that you wrote for them back in 2020. How did that project come about and what were the key takeaways?
Hi, Laura, and thank you for having me. We started the Unsafe for Scrutiny project 3 years ago because we were concerned about risks and threats to journalists, specifically that uncover financial crime and corruption, and particularly when that financial crime and corruption is linked to the UK. We're well aware that London, sadly, has the name Londongrad and is a hub for dirty money. And we saw with that there were also a lot of threats and violations being carried out against those who try to uncover it. So the first report we did, which we published in November 2020, was actually the findings of a global survey. We conducted that survey over a couple of months. We had responses from 63 journalists working in 41 countries, specifically working to uncover financial crime and corruption. And more than 70% of them were facing some kind of risk and harassment. We were looking at all kinds of threats, whether they were physical, digital, psychological, and legal. Concerningly, they were also about the same amount that were facing legal threats. And for me in particular, based in the UK, it was very alarming that the respondents of that survey identified the UK as an international leading source of those threats. So almost as many coming from the UK as those coming from EU countries and the US combined. And so that really kind of shifted our focus from looking at kind of a wide range of violations to looking more specifically at legal threats and what we now kind of commonly call SLAPPs. But at that time, we were not really using that term in the UK, and it wasn't an issue that was sort of as well known.
So let me make sure I heard you right. You said out of this global survey, more than 70% of the recipients were facing some form of threat for exposing financial crime and corruption. Is that right?
Yeah, that's right. Yeah. So there was a lot of respondents who were facing, physical attack or, smear campaigns, on and offline harassment. But 70% of them, 73% of them, sorry, had been subject to some form of, kind of legal threat. And moreover, half of those then said that it was the legal threats that posed the greatest challenge to their ability to continue reporting. So even if they were facing other forms of harassment or violation, it was the legal threats that were the most challenging for them to be able to continue their work, largely because of the great amount of financial risk it puts a journalist under, and the potential ultimately to shut down their publication, or if they're a freelancer, to stop them working at all, just because of the legal pressure and the financial cost that comes with that.
That's just a staggering figure, and your description of why it shuts down the publication is perfectly understandable. When you're exposed to significant financial risks, it's very hard to continue doing what you're doing. Was this the first that you had heard of SLAPS doing this report? And were there any particular cases that were in the UK courts that caught your attention?
So I previously worked for Article 19, which is an international human rights organization that specifically works to defend freedom of expression. And while I was still there, sadly, the Maltese journalist Daphne Caruana Galizia was assassinated, that was a tragedy in its own right. But I think it was also instrumental in raising awareness of the issue of SLAPS. At the time of her murder, Daphne had almost 50 legal cases open against her, and she'd also received legal threats from the UK and the US. So I think that was kind of a big awakening for a lot of people within Europe and human rights organizations, and certainly led to, all the developments that we've seen now in the EU and the attempts to bring legal change there. So aside from Daphne, at the time that we started the Unsafer Scrutiny Project, I was also aware of a recently concluded case that had been brought in London against Paul Radu, who is the co-founder of the Organised Crime and Corruption Reporting Project, OCCRP, the organisation that has been responsible for many of the kind of famous international journalistic investigations like the Paradise Papers, the Panama Papers. And he had been pursued for 2 years in the UK courts by an Azerbaijani MP and businessman who was unhappy with his inclusion in the Azerbaijani laundromat investigation and had taken legal action against Paul, who, interestingly enough, is a Romanian citizen, and OCCRP are registered in the US as a media outlet. But this Azerbaijani sitting MP had brought the case in London, which was, particularly interesting, and kind of points to why there is a prevalence of cases in the UK and what makes the UK such an attractive jurisdiction. Which perhaps we can get into in a bit more detail. But that case went on for 2 years before ultimately being settled on the eve of the trial. And it cost OCCRP almost, they had to raise something like $500,000 in order to defend it, which again is not uncommon amount to see a case to trial. So that was the one case that I was aware of kind of going in London that was relatively high profile in the sense of the organisation and the journalist involved, but at the same time, I wasn't aware of kind of just how that was really kind of the tip of the iceberg. And subsequent to the publication of our early Unsafer Scrutiny reports, we started to try to dig in and find more case studies. And I've always likened it to kind of pulling on a thread on a jumper. It's like kind of get those first couple of loops and then suddenly the whole thing unravels. And I think a lot of the work we've done over the last 3 years is just to really surface a lot of cases. And there were a couple of cases that happened sort of the year after the report came out, with two quite high profile journalists again, but also who had written books. Catherine Belton, who wrote a book called Britain's People, how the KGB took back Russia and then took on the West. And she was subject to what was described popularly as a sort of a legal pylon. She was sued by 4 Russian oligarchs and the Russian state oil company. And then Tom Burgess, who is also an investigative journalist and written a book called Kleptopia, How Dirty Money is Conquering the World, had also been subject to legal action by a Kazakh originally, a company called ENRC. So, those 2 cases, I think, were quite instrumental in raising the wider awareness of the issue of SLAPPs. But I think we were also seeing the emergence of a greater understanding of what SLAPPs are and how they work and how they are particularly prevalent in the UK.
Were there other issues in the world that also helped to shine a spotlight on why these are particularly problematic in the UK?
Yeah, well, I mean, I think those 2 cases, which were kind of largely playing out already publicly in 2021, and obviously you can kind of tell from the subject matter of their books that it was kind of very much linked to issues around corruption. And so there was an early parliamentary debate at the start of 2022 on the topic of SLAPPs. And so I'd say that, there was awareness growing at that point, and certainly, interested parties, parliamentarians keen to sort of look at addressing it. But undoubtedly, Russia's full-scale invasion into Ukraine in February of last year put a spotlight on this issue like never before, and definitely increased its importance within the political agenda. Very quickly after the invasion, then Foreign Minister emphasised that addressing issues on SLAPPs would be part of the UK's response to the invasion. And our former Justice Minister, who has since left, but was very instrumental uncovering evidence last year.
So the war in Ukraine, I think that the issue primarily there, right, is that the Russians are trying to control the narrative through the courts.
I think, the sort of political importance put on addressing SLAPPs was very much seen within the context of, the response to Russia's invasion, a full-scale invasion into Ukraine, and there was a lot of action suddenly around dealing with dirty money and foreign influence in a way that many organizations, a lot of transparency, anti-corruption organizations have been campaigning for years in the UK. And then suddenly, there was this huge amount of interest in actually taking some action. And I think particularly Catherine Belton's case, given the subject matter of her book and the fact that she had been sued by several of the oligarchs who were then subject to sanctions as a result of Russia's war, really kind of put into sharp relief how SLAPPs are part of a wider toolkit, particularly those who are enriching themselves through kleptocratic means. And while it's quite possible to suppress information about those wrongdoings domestically, say in countries like Russia, how useful SLAPPs are as a form of shutting down scrutiny of that wrongdoing in countries like the UK, and also serving to kind of we talk about money laundering, but also reputation laundering. So using legal tools and tactics to basically shut down public scrutiny and try to enhance somebody's reputation. And so, the UK, I think, particularly after the invasion, woke up to the fact that it was not only potentially open to all this kleptocratic influence, but actually it was serving as providing the services to enable it. And so it is encouraging now that there has been action, but certainly there was a lot of awareness, both on corruption issues, but also SLAPPs growing before that point as well.
It's interesting the way that you describe it, both as in your studies of SLAPPs, how it's like unraveling a thread, because you saw that there was such a proliferation that you might not have originally seen on the surface, but you dug deeper and you saw that as you researched more, there was so much more to see. It sounds like your research also allowed you to see that this issue of judicial harassment through SLAPPs as you said, was only part of a wider toolkit, all of which is for the purpose of shutting down this scrutiny. Is there a particular issue in the UK that makes it such a friendly forum? I mean, when you were describing your report and saying that the UK had more SLAPP suits than almost all of the EU and the US combined, what about the UK judicial system makes it the plaintiff's haven for defamation suits?
The UK is generally seen as an attractive jurisdiction for a number of factors. Firstly, the burden of proof is on the defendant, which is, unlike the US system. So there's a lot more onus on the defendant having to prove what the meaning is decided to be, which is, it sounds very simple on the surface of it, but I think Paul Radu, who I mentioned earlier, kind of has put this very well in terms of his experience. Journalists are in the business of presenting facts. What the reader then draws from that is kind of their own conclusion, right? But the problem is that it's not the facts that are presented, but the meaning that those facts can convey that's decided upon by a judge at a very early stage. And so you can end up having to defend the case based on something you didn't actually say. And we have seen that be problematic in some cases. For example, the Carole Cadwalladr case, a British investigative journalist here who was sued by Arron Banks. And there was a single meaning very early on, which, Carole clearly went beyond what she thought she was saying. And unfortunately, from that point onwards, you've got to then defend that. And there are a certain number of defenses open to you, including the truth defense. And Carole had to drop that because, that was not what she thought she was saying. And then in terms of like the process in the UK, it was extremely expensive. It gets expensive from a very early point, even sort of dealing with legal letters and early hearings can be, you're not talking thousands, you're talking tens of thousands once it's got to court in an early stage. And then generally, I'd say on average, to take cases to trials, you're looking at $500,000 as a floor, really. The cost can increase. And then, of course, damages can go upwards from there. And it's also very lengthy. So I would say that the cases that we've seen, we don't see many cases getting fully to trial. We see cases, there have been quite a few cases that we looked at in the London Calling report, for example, that ended just before getting to a full trial. But they're still taking 2 years to get to that point. And one of the cases that we examined in the report and was when we were following as a coalition was a case of Swedish journalists. And between their early kind of meaning and jurisdiction hearing and the actual hand down of the judgment of that hearing was over a year, something like 15 months. So you have all that time where the journalist is, effectively kind of on hold, dealing with legal matters and sort of anxiously waiting the outcome. And it's a very heavy burden to bear, really. So I think another factor is that you often see in UK cases that not only are publications taken to court, but it's quite common to see individual journalists being sued as well, alongside their publication or sometimes on their own. And in other countries, that's not always possible. So the Swedish case that I mentioned, which was a case of a Swedish business publication called Realtid. It's published in Swedish in Sweden, but of course available online anywhere. If the businessman, who was also Swedish, and his company, which was registered in the UK, had decided to sue in Sweden, which they didn't, they wouldn't have been able to sue the individual journalists. So I think it's quite interesting that case got brought to the UK. And certainly the pressure that's added when you're also sued as an individual can be quite high, particularly if you're not included. You see quite a few freelancers aren't included necessarily on the insurance policies of their publications. Not every publication's ready to defend all of the people that write for them. So yeah, it's a very complex picture, but in general, the burden of proof being on the defendant, the high costs involved, the lengthy process, and then the kind of wider landscape of, being able to kind of really ramp up the pressure, particularly on individuals, is probably the key factors that make the UK so attractive. And then the fact that, it is quite a low bar, generally speaking, to establish yourself as having a reputation here in the UK. The previous reform to the Defamation Act, which was in 2013, was supposed to stop libel tourism. But I think it kind of underappreciated the fact that a lot of people can establish themselves as having a reputation in the UK through buying property, through, getting investment visas, sending their kids to school here. And all of those things are things in particular that kleptocrats like to do. And kleptocrats also like to shut down any scrutiny of their activities. So there's been a bit of a kind of loophole there, I would also say, on that front.
It's just fascinating. There's just a myriad of influences that appear to all point in the direction of the benefits of filing such a lawsuit in the UK. And one thing that you didn't mention that is also a factor anywhere a SLAPP suit is filed against a journalist or a human rights defender or any individual is just the time that's taken away from their work. It's also the distraction of having to deal with legal proceedings rather than doing the job that they are supposed to be doing and informing the public about matters of public concern. So there's just a staggering effect on folks all the way around, financially, emotionally, from the standpoint of getting their job done and other areas of their life. I'm curious as to how the Foreign Policy Center and others helped to spread awareness about SLAPPs. You had mentioned in your study that you knew about SLAPPs because of your previous experience at Article 19, but really didn't know the breadth and the depth of the SLAPPs that existed. How did y'all help to spread awareness about SLAPPs in the UK so that others were brought up to speed on this phenomenon?
Well, I think that the sort of early findings of our research in 2020, as I mentioned, really kind of highlighted how important this issue is and the potential scope and scale of it in the UK in particular. And so together with a colleague from Index on Censorship, we decided to set up the UK Anti-SLAPP Coalition, which is also now chaired together with English Pen. And it started, it's an informal working group, but we now have around 30 members, organizations, but also we have more members who are just sort of independent researchers or lawyers or academics, all concerned about this issue. And from the very start, our intention with the coalition was to do more research, to monitor ongoing cases, highlight cases publicly. So, Index, for example, is a member of the Council of Europe platform for media, for the safety of journalists. So they're able to raise media alerts on particular cases, as well as release public statements with other members of the coalition. But from the very beginning, we were really keen to develop remedies, really kind of look at what solutions could be put in place for mitigation and redress. And, we were very fortunate. We were not starting from zero. Obviously, there was a wealth of experience legislatively from the US. And I know Charlie Holt, one of my co-chairs, really benefited. We really benefited from him because he had already had experience working on SLAPPs, anti-SLAPP laws in the US and also in Europe. And certainly kind of our work was coming alongside at the same time as the work of another coalition, the Coalition Against SLAPPs in Europe case. And so I think there was a kind of, groundswell, particularly in Europe, of awareness raising that sort of complemented each other. Particularly at FPC, we have been holding now annual conferences, the UK Anti-SLAPP Conference with our partners, the Justice for Journalists Foundation and the International Bar Association's Human Rights Institute. So we've held two already. The first one was in 2021. it was a 2-day conference. We had a lot of panels focused on the UK, but with the participation of a lot of journalists and lawyers and others from all around the world. You've been a contributor, Laura, sharing your expertise from the US, and I think that's been very useful in helping particularly key stakeholders understand the problem, and also understand that this hasn't started from nowhere. And that there are actually already solutions out there that we can, adapt for a UK context. So last year's conference was much more focused and much more targeted on what are the solutions. And to coincide with last year's conference, the coalition published a model UK anti-SLAPP law. And we're really pleased that that's been really welcomed by civil society and endorsed by media. Just after it was released, more than 70 editors, journalists, academics, lawyers, and others in the UK signed an open letter to our then Justice Minister Dominic Raab, calling on the government to introduce a law, a UK anti-SLAPP law in line with our model law, which was incredibly encouraging. I mean, at that point, the UK government had already committed to legislating last July, having held its own call for evidence immediately after the Russian invasion into Ukraine. The Ministry of Justice here held a 2-month consultation on this issue, and they concluded that SLAPPs were having a chilling effect here in the UK. And last July, they committed to decisively stamping them out, which was great. But we actually hadn't seen any action until about a month ago. So I think we're probably going to come on to that in a little bit more detail. But I think, we're pleased that the conferences have kind of really kept these topics on the agenda and hopefully been helpful in providing kind of useful solutions. Aside from legislation, we've also done quite a lot of work on regulation. But
I will tell you, Susan, you've done a remarkable job with these conferences, not only in, as you've said, proposing concrete solutions, but also in raising awareness of this issue being a global phenomenon. I know there were speakers last year from Brazil and elsewhere, and in discussing other ways that SLAPP suits can be combated through better regulation of the industry. So I would love to talk about all of that. Before we get into the regulation piece of it, let's talk about the most recent legislative component. Did the UK Parliament decide to adopt the model anti-SLAPP law that the coalition put together? Or where do things stand with Parliament?
So last month, the UK government announced an anti-SLAPP amendment to a bill that's currently going through Parliament at the moment, which is the Economic Crime and Corporate Transparency Bill. And this amendment is basically the first attempt by the government to put anti-SLAPP measures into legislation. And if the bill is adopted, which hopefully it will be later this year, it will mark the first UK anti-SLAPP measures, which is exciting. It is not a copy of our model law, although there are elements in it which are kind of complementary. The most obvious criticism is the fact that it is limited in scope to economic crime and corruption. And while, especially as somebody who has researched a lot of cases with an economic crime and corruption edge and angle, that's encouraging, it's definitely not the whole picture. So we looked at about 35 cases last year when we published our report called London Calling, and about 70% of them had some connection to economic crime and corruption, but not all of them. And I think it's important to say that our research lens was always looking at those kind of cases, whereas we know that that's not the only topic that SLAPPs are used for. And I think while the government has already committed to extending the legislation further beyond economic crime when parliamentary time allows, I think it would have been our preference if they had started as a coalition, if they had started with that, because it's a bit of a concern that it's going to create effectively a kind of jigsaw issue where some SLAPs are receiving, protections, and other cases are not. And we've already seen that. One of the most kind of notable cases, SLAP cases, that got a lot of public attention at the beginning of this year was the case brought against Eliot Higgins, who is the founder of Bellingcat, an open source investigative media outlet, which published published quite a lot of articles about Yevgeny Prigozhin, who is well known now as the head of Wagner Group, one of the mercenary groups fighting in Ukraine on behalf of Russia. And Eliot was sued by Yevgeny Prigozhin in the UK for 5 tweets that Higgins had posted, 2 news articles making the link that Prigozhin was the head of the Wagner Group, which we all know very well now. But 18 months ago, Prigozhin was trying to deny that. He'd already been subject to sanctions in the UK since 2020 for mercenary activity in Libya. So that was sort of seen as subsequently as his attempt really to kind of clean up his reputation, potentially try to push back against the sanctions against him. But he was successful in launching the case in the UK and taking the case as far as kind of the early stages before his legal representation, the law firm in the UK, Discreet Law, that had taken on his case, decided to withdraw their services after Russia's invasion into Ukraine. And then the case was eventually thrown out by the judge because Prigozhin was not kind of complying with court orders and wasn't able to take the case forward. You could say that was a sort of success story in the sense that the case got thrown out. But that was several months after the case had been started, and Eliot Higgins was ultimately left £70,000 out of pocket. And that case would not be covered by the amendments and the measures that are being proposed now by the UK government, because it didn't relate to Prigozhin's financial affairs. It related to whether or not he was the head of the Wagner Group. So that's probably a kind of key example of a case that would fall through the cracks. Certainly, Tom Burgess's case, he was being sued over kind of questions regarding the murder. Some whistleblowers involved in mentioned in his book. That's not a case that would have been covered by these amendments. And there's questions whether some of the cases that were, or some of the meaning claims that were made against Catherine Belton and her publishers would have been covered by this either. So, a good first step. We've certainly welcomed it as a coalition, but it certainly needs to be extended. And I think the most sensible thing to do would be to introduce a UK anti-SLAPP law, covers all kinds of SLAPP cases. It's about whether or not topics are in the public interest, and not just about a specific aspect of that. And then the amendment itself has some positives, but also, it's about whether or not it can be effectively implemented. And certainly we as a coalition have some suggestions about how it could be strengthened. So positive, but not the kind of end result by any means.
I think I read an Article 19 representatives describing this as a stepping stone, but not a final destination. And that seems like what you're conveying as well. The Eliot Higgins case that you mentioned, I think, is a wonderful example for our listeners to understand that even when the SLAPP victim ultimately is successful, the opponent just gave up. Even when they win in this scenario, they lose. And I think Paul Radu had said that as well, because he's stuck with the legal fees. He's been distracted from his work all of this time. He's had the mental anguish that he's had to deal with. And so even though he technically won the case, he really lost so much as a result of this meritless claim being brought against him. And I think that's what SLAPP reform is all about, is getting back to that level playing field so that the victim of judicial harassment in the form of SLAPPs is made whole. What is the timeline for this Economic Crime and Corporate Transparency Bill amendment to pass? And then is there a timeline for a larger protection to be adopted in the UK?
So the amendments, when they were brought forward by the government to the Economic Crime and Corporate Transparency Bill, were brought forward during the Lords stage, which is the UK's Parliament's upper house. So the bill, having already been through the Commons, the lower house originally, and now the Lords, it's now gone back to the Commons, but we've broken for there's parliamentary recess for the summer. So the bill's expected to come back to the Commons in the autumn. There's no specific date at the moment. I imagine it might be around sort of October time, and then hopefully be brought into law shortly afterwards. And in terms of any other timeline for any other legislation, the government has just been repeating the line it used to say on any measure for SLAPPs, which was when parliamentary time allows. So who knows when that could be.
Well, it sounds like you're not resting on your laurels, though. You've got the Parliament acting with this amendment. You're continuing to push with larger protections being adopted. Tell our listeners about what else is being done in this more holistic approach to reform, including the good work that you've been doing with the Solicitors Regulation Authority.
Yeah, so I think as a coalition, we've always seen that there's sort of three spheres to work on. The first one being the legislation, which we've covered. The second one is regulation. And the third is really a kind of cultural shift. And the cultural shift's related, I think, both to legislation and regulation. But a lot of the reason that SLAPPs are, taken forward is because there are lawyers who are willing to represent those who wish to bring them, represent the claimants. And there are concerns in the UK about these cases, and particularly when there is a link with kleptocracy potentially, and the potential for dirty money to be used to fund SLAPPs. And so from quite an early point, we started talking to the Solicitors Regulation Authority, which is the body that regulates solicitors specifically in England and Wales, and we approached them with the findings of our initial unsafe for scrutiny reports, and they kind of were saying this was really something that they were not so aware of, but expressed concern. And they have been quite engaged kind of ever since, and particularly since last year when the government held its consultation on SLAPPs, and it concluded that SLAPPs were having a detrimental effect in the UK and having a chilling effect. Solicitors Regulation Authority was kind of one of the, if actually it's the only regulator that's taken a really decisive approach and been proactive in trying to look at measures. They opened, last July, initially 20 investigations into potential SLAPP complaints, a number of which were linked to the information from the London Calling report. But they've now, I think the latest count was sort of upwards of 50 open investigations. They also took forward one of our recommendations, which was to introduce a warning notice on SLAPPs. So the warning notice is a sort of educational and regulatory tool. So it sort of proactively warns the members of the SRA of their obligations, but then also provides a framework for complaints and for regulation. And so that was very encouraging. There was a warning notice already introduced about 4 or 5 years ago on the use of NDAs, which I think created quite a useful template for SLAPPs, and there's quite a few parallels, I think, in those issues. The warning notice was published last November, and it really kind of clearly points to the SRA's concerns about SLAPPs and the potential for abusive conduct by lawyers, making threats in correspondence, which could be unjustified or even illegal. They've particularly referenced in the warning note concerns around the mislabeling of letters, so letters that are going out. And I think this is the really key thing about regulation, because obviously the legislation and the legislative initiatives will tackle SLAPP cases when they reach court. But a lot of our research, and I think, speaking to a lot of journalists and media outlets, a lot happens even before it gets to the court stage. So all cases will start with letters being sent, and these can often be really unduly aggressive and intimidatory, make kind of really big claims about the amount of damages, and make unreasonable requests, for all information to be taken down, for the law firm's client never to be written about again, for unequivocal apologies, for things that would be beyond what could be, reasonably understood as a request, and sort of bad faith kind of responses to the right to reply requests, things like this. And so the warning notice does, kind of set out concerns about certain types of behavior, certain types of labeling. When I was meeting with journalists and trying to sort of dig out more information in the early stages, there were people who had letters and they were too afraid to talk to me about them, let alone show me them, because they were labeled private and confidential and not for publication. And they were, people were sometimes afraid that there might be some legal consequences to talking about them. But I think we understand now, there's been a lot more public debate about this, that those labels are meaningless. It is possible to send a letter where there is private and confidential information, but ultimately you cannot impose a blanket requirement for someone to keep confidential information you are sending them. To infer a duty of confidence on someone who's not signed up to it. But it was also very successful in therefore suppressing not only whatever the information was that the journalists or media outlet were publishing, but the fact that there had been any legal threat at all. And I think that's also partly why it's taken a long time for this issue to be addressed, because we just, there was a kind of, a silence over this issue. And what's been quite encouraging, and this leads on to the kind of cultural change, is that over the last 2-3 years, we've seen so many more people talk about the legal threats they received, and to speak up about it, and to, say at an early stage that they're being threatened, and not keep silent about it, and to potentially even publish the sort of SLAPP letters they're getting as part of the public interest reporting. And while we would very much, emphasize that everybody should take their own legal advice and take their own view, it is interesting that a number of these legal threats have dissipated as a result of people going public about them and reporting them, which sort of goes to show that the intention really was more about suppressing the information than about genuinely seeking a recourse for defamation or for any other violation that the claims are used for.
It sounds like what you're describing is really just a scare tactic that has been employed, and unfortunately it's worked for quite a long time, and it's worked to create silos of silence, and those silos of silence have kept the public from becoming aware of the prevalence of these threats, because the threats present as though there is some sort of a unilateral obligation to keep information confidential, and that information is this threat of a legal claim. And so the good work that y'all are doing in raising the awareness through the SRA of how this is not acceptable behavior on the part of the lawyers who are representing these folks is absolutely critical to the greater public awareness of SLAPPs, and to having those victims, those recipients of the letters, feel more confident in exposing what is going on here. So great job in also shifting the cultural awareness. We so appreciate everything that you have been doing on the UK front and elsewhere, and I think the SRA's actions are going to be actually something that's going to help lead a global shift in awareness for lawyers and solicitors in the way in which they act. How can our listeners get involved and help in this process if they would like to do so?
Well, certainly if there are any listeners who've been subject to SLAPPs or attempted, SLAPPs in the UK, please get in touch. We have a website now as a coalition, antislap.co.uk. And actually, I think that's right, Laura. Now I'm worried that's not the right. It's Anti-Slap UK. I should know that better. Yes, we have a website now, Anti-Slap UK, and so you can find more information there. There's more cases, case examples, and also you can find our model law there and other information about the various initiatives that we're working on. And you can sign up also for more updates on future actions that the coalition is planning. And I'm sure we would be very welcome of your support.
Well, thank you so much for all your hard work in this area. I hope you'll come back and tell us how it all turns out. There's so much more that lies ahead, and we really appreciate all that you've done. Thank you for being here today, Susan.
Thank you, Laura. Thanks for having me.
Thanks, Susan and Laura. For more on UK anti-SLAPP efforts, check out Haines and Boon's website, where you'll find an article written by Laura from January called Making Strides Toward UK Anti-SLAPP Law and Crackdown on Attorneys Who Bring SLAPP Suits, and visit the UK Anti-SLAPP Coalition website, which is antislap.uk, where you'll find updates on key UK anti-SLAPP developments, how to report a SLAPP suit to the SRA, and more valuable information about this global phenomenon. Thanks, everyone.